Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Michael Corey, inmate number 245709. Today is Tuesday, March 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office. Counsel?
Yes, Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit representing Michael Corey. My client received a new sentence out of court, and his new max court sentence goes beyond his supervision with his parole violation. So after speaking to my client and giving him all the potential scenarios, my client has elected to waive the revocation hearing today on the record. Thus, his presence is excused. I do represent him, and I did ask to waive his presence, and we are waiving the revocation hearing on the record today with the understanding it still has to go through protocol, still has to go to board review, and the decision still has to be made on this case.
Yes, I accept your Mr. Corey's waiver, and his hearing will be conducted administratively, and his board review is scheduled on March 13th, 2025.
Thank you.
Thank you. Good morning, P.O. DeValder.
Good morning.
We'll get started in about 15 minutes.
No worries. Thank you. Good morning, Attorney Famiglietti.
Good morning.
We're going to get started in about 15 or so, like 10 to 15 minutes for Mr.
Yep,
Hauser.
That's what I figured. Good morning. Thank you so much.
No problem.
Was your 9 o'clock canceled?
Yeah, he waived on record.
Oh, okay. Thank you. Didn't know that.
No problem.
Thank you so much.
No problem. Good morning. Can you hear me?
Hello? Yeah, we can hear you, but the screen's all black.
Okay.
Oh, there we go.
Okay.
We'll just be loading. There you go.
Okay. Thank you. We'll get
You're
started
welcome.
in a few minutes, Mr. Hauser.
Okay, thank you.
Thank you. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning David Hauser, inmate number 430649. Today is Tuesday, March 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Cybulski Correctional Institution. Please state your full name and DOC inmate number for the record.
David Hauser, 430649.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
As well as your parole officer.
Good morning, Parole Officer Devahn with Hartford Special Management Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Hauser and P.O. Devahn, please raise your right hand. Do you solemnly swear, or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes,
you.
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, both the state as well as your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you very much. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
Thank you. We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. DeValder, starting with charge 1, restriction on pornography.
Beginning 12/10/2024 through 1/6/2025, you intentionally and purposely viewed sexually stimulating material nearly every day on your monitored electronic device. Per your special condition of parole, you are not to access, view, or possess any pornographic material by any means. Due to the nature of your instant offense, you are prohibited from accessing any pornographic material as it both impedes your rehabilitation and places the community at risk. Charge number 2.
Go ahead.
Enhanced internet and device monitoring. Since your placement at Chrysalis, you purchased, installed, and had been operating a personal Xfinity Wi-Fi wireless gateway and admitted to this on 1/7/2025. You are serving a sentence for a sexual offense where the internet was used in the commission of the crime, which requires you to pay for a software program to monitor your use of all devices. At no time were you given permission to obtain this device, nor was the device monitored as required. On 1/7/2025, an unreported and unapproved USB device was found during a search of your residence. At no time are you to have an unreported electronic device. Charge number 3, problem sexual behavior treatment. A search of your residence conducted on 1/7/2025, you were found to be in possession of an unreported and unapproved Xfinity Wi-Fi wireless gateway and a USB device. Per your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior, you are restricted from accessing any electronic devices. Thank you.
Oh, there's still 2 more charges.
Oh.
Or the rest of the charge 3.
Oh, sorry.
Okay.
Beginning on 12/10/2024 through 1/6/2025, you intentionally and purposely viewed sexually stimulating material nearly every day on your monitored electronic device. Per your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior, you are restricted from possessing any sexually stimulating items and/or viewing any sexually stimulating material. On 1/1/2025, you were attempting to log into Facebook. You are restricted from any use of social media, and you purposely and intentionally were trying to access the social media platform. This is a violation of your signed treatment agreement with the Center for the Treatment of Problem Sexual Behavior. Thank you.
The state's exhibits were marked and identified at the preliminary hearing held on January 27th, 2025. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, we have.
Okay. And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and at this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. P.O. DeValder?
Yes. I would just like to reiterate that Mr. Hauser and Mr. Hauser alone is responsible for any and all materials and information contained on any of his electronic devices, to include the one that he has electronically monitored. He purchased his own wireless gateway, which was unmonitored and unreported, and had a USB drive in his backpack in his single-bedroom apartment. The material contained on Hauser's phone not only violates, but also illustrates a blatant disregard for his parole conditions and the Center for the Treatment of Problem Sexual Behavior treatment. Excuse me. To highlight some of the themes contained on Hauser's phone include incest between father and daughter, adult men falling in love with minor females, bondage, oral sex, masturbation, and adult sexually stimulating images. In addition, he attempted to log into Facebook and was searching for adult stores near him. The provided evidence clearly demonstrates that his behavior is in violation of all the charges the state has presented. Thank you.
Thank you. It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Yes. Regarding the preponderance standard and the elements of possessing the USB device, that was cleared with Officer Ludovenko. My client's sister sent him that USB device while he was at the January Center. That was purchased, and the only information on that is his resume and documentation regarding him filing a grievance. That was the sole purpose of his having that USB device. There's no contraband. There's nothing on that USB device that's illegal or contraband in any way, shape, or form. And most importantly, he was given permission to possess that. So I don't believe that meets the preponderance standard regarding that portion of charge 2 and 3. The charges in charge 1 and 3, the allegation is that he intentionally and purposely viewed. That's the verb used, viewed. I know it alleges possession in certain places, but the claim is that he viewed these documents or this information, this alleged contraband. No evidence in any of the exhibits or any of the testimony has been offered to support that he intentionally and purposely viewed anything. So not only does it not meet the preponderance of the evidence standard, there's no evidence to support any claim that he viewed anything. Lastly, regarding charge 2 and charge 3, there's no proof that my client purchased anything. Now, it may have been there. They may have found in that housing unit a device, the Xfinity wireless device, but it's consistently and always been my client's claim that it was there when he entered the apartment. Now, whether or not he should have told someone about that, that's another issue. But the allegation is that he intentionally or that he purchased and installed this, and there's just simply no evidence of that. Thank you.
Thank you. Peel DeValder, anything further?
Yes, I would just like to say the IPPC monitoring software does monitor the use of his phone. So any information that was entered is reflective in the evidence I provided. So that just does prove that he was viewing that information to include all of the pornography. And in regard to the Xfinity Wi-Fi gateway, I did contact the Chrysalis department and they confirmed that that is not their device. So that was something that was brought into his apartment on his own.
Thank you. Counsel?
Just briefly, just because it's not Chrysalis's and wasn't purchased by Chrysalis doesn't mean my client purchased it. And
it is a single bedroom apartment.
Ma'am, I'm not arguing with you. I'm making a legal argument. This is not a back and forth here. I'm sure at some point you'll have time to speak, but I believe it's my time now.
Yes, Peel DeValder, you'll definitely have another opportunity.
There's absolutely no evidence that he purchased that. We can assume anything we want, but there's no evidence. This is a legal hearing. We can't assume things. We can't assume he viewed it. There's no evidence he viewed it. Thank you.
Thank you. Peel DeValder?
No, I have nothing further.
And counsel?
Nothing further as the preponderance standard. Or
Thank you very much.
Evidence.
I'm going to take a moment before I announce my findings. Regarding charge 1, restriction of pornography, I make a finding based on state's exhibits B, D, and J. Charge 2, enhanced internet and device monitoring, I make a finding based on state's exhibits B and D. On charge 3, problem sexual behavior treatment, I make a finding based on state's exhibits B, D, E, and J. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history as well as your parole officer. P.O. DeValder, do you wish to make a statement regarding Mr. Hauser's background and history?
Yes, I would. So Mr. Hauser has had 3 criminal convictions for sexually related offenses. Due to the nature of these offenses, the Board of Pardons and Parole has set very specific conditions for community safety. He spent just about 5 months in an inpatient treatment center for problem sexual behavior before his release into the community. It is apparent that any techniques he learned to cope with his sexual deviancy have not resonated with him, as within a month and a half he was remanded to custody based on these similar behaviors. Even on his date of remand, he stated that he knew enough that he would not be able to view such materials in the January Center, so how does he justify the same behaviors on special parole? The subject matter contained on the device he is responsible for significantly poses an increased risk for him to reoffend, is a concern for public safety, and is an unwillingness to comply with his conditions of parole. The state requests that his parole be revoked and that he serves a sentence of a minimum of 9 months. Thank you.
Thank you. Counsel, you should make a statement regarding Mr. Hauser's background and history at this time.
Yes. The client is a divorced 61-year-old male. He has 2 sisters from whom he receives primary support. He has 2 adult sons, ages 22 and 19. Back in 99 and 2000, he began taking general studies courses at 3 Rivers Community College. He had been working in the past briefly as a process technician for Vanguard Plastics Corporation. He participated in CTPSP programming. He has been saving actively for independent housing. He'd like to be housed independently. He wishes to be placed in a halfway house in Hartford or Middletown. Ultimately, he'd like to obtain his own apartment. He is eligible to return to his full-time position as a process technician at Vanguard Plastics in Sylvington, Connecticut. He's amenable to all treatment recommendations. Even if we take all of these allegations as true, no human being was harmed whatsoever here. None of these crimes are of any alleged violence. There's no crimes that he's alleged to have committed. There are no graduated interventions or sanctions whatsoever in the time that he was released to the January Center on June 25th, 2024. I don't see any need to warehouse him in jail any longer. As I stated, he hasn't harmed anyone. I think a lengthy jail sentence as the 9 months is purely punitive. We'd ask that he be immediately released to the supervision of parole. We don't believe the nature of this violation is so serious enough to warrant further incarceration. He's been incarcerated since January 7th. We don't believe further confinement is necessary or appropriate. He's not receiving any treatment whatsoever while he's incarcerated. He will be released at some point in time. Why not release him now so he can begin treatment? Thank you for your time and consideration.
Thank you. P.O. DeValder, anything further?
No, thank you.
Okay. I'm just going to take a moment before I make my recommendation. Okay, Mr. Hauser, I see that this is your first parole violation. You were in the community for approximately 6.5 months. Within that time frame, there were no noted misconducts or interventions or graduated sanctions. Taking all of that into consideration, I recommend revoke and reparole on June 9th, 2025, which is a 5-month sanction with the following conditions. Enhanced internet and device monitoring, halfway house placement, mental health evaluation, no contact with minors, problem sexual behavior treatment, and restriction of pornography. My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on March 13th, 2025. On that day, the board can either adopt my recommendation, they can go lower, or they can exceed my recommendation, being that you're on supervision until June 2029. You'll receive written notice within a week of March 13th. Okay?
Yes,
So,
ma'am.
sir, give me a telephone call on the 14th of March, our office.
Yes,
On
sir.
on the 14th of March, we'll tell you what their decision was. Okay?
Yes, sir.
Okay. So have a good day and thank you very much.
Okay, thank you.
Thank
You're
you.
welcome. Take care.
Thank you.
You're all set, sir.
Okay, thank you, sir.
You're
Thank you,
welcome.
ma'am.
Have a good day.
You too. Thank you.
Bye-bye.
Good morning.
Good morning.
We should have Mr. Garcia with you this morning.
Yeah, he's not here as yet, but as soon as he comes, I'll have him seated.
Okay, thank you.
Okay. Hi, I'm still waiting for the inmate to arrive.
Okay, I'm here.
Okay.
Good morning.
Good morning. How are you?
How are you?
I'm okay. How you doing?
Good. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a
Okay.
revocation hearing concerning Edward Garcia, inmate number 426623. Today is Tuesday, March 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Edward Garcia, 426623.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Garcia, please raise your right hand. Do you solemnly swear and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you.
You're welcome.
First, I will read you your rates. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
What does that mean?
If you want
If I wait for an attorney, will they be here like right now, or will I have to come back at a later date?
Yeah, you would. If you wanted an attorney, I would continue your hearing until my next available date, which would be March 18th.
Okay, no, so we can proceed. You seem like a nice lady.
So we'll move forward. Okay. So you have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, residence. On March 1st, 2020, you left Central Ave, your only parole-approved residence, on an approved pass and failed to return at your scheduled return time. Your whereabouts are currently unknown. Charge 2, absconder. On March 1st, 2020, you left Central Ave, your only parole-approved residence, on an approved pass and failed to return at your scheduled return time. Your whereabouts are currently unknown. Charge 3, drugs. On February 24th, 2020, you submitted a toxicology that tested positive for non-prescription Suboxone. You signed a voluntary admission of positive test results for prohibited substance form indicating that you had used a non-prescription of Suboxone on February 22nd, 2020. Charge 4, halfway house placement. On March 1st, 2020, you left Central Ave, your only parole-approved residence, on an approved pass and failed to return at your scheduled return time. You failed to have any further contact with parole or halfway house staff. Your whereabouts are currently unknown. Charge 5, mental health treatment. On February 18th, 2020, you were assessed at Connecticut Renaissance outpatient for mental health, gambling, anger management, and substance abuse issues. Your course of treatment was intensive outpatient treatment 3 times a week, starting on February 19th, 2020. You had an unexcused absence from required treatment on February 21st, 2020 and February 28th, 2020. You were unsuccessfully discharged from your outpatient program as a result of your actions. The state has filed the following exhibits. Exhibit A, conditions of transfer parole. Exhibit B, halfway house agreement. Exhibit C, Connecticut Renaissance client status progress report. Exhibit D, client infraction. Exhibit E, voluntary admission form. Exhibit F, toxology. Exhibit G, client status progress report. Exhibit H, Connecticut Renaissance incident report. Exhibit I, Connecticut Renaissance discharge summary. Exhibit J, Connecticut Renaissance outpatient discharge summary. Exhibit K, remand to custody order. Exhibit L, parole violation report. And Exhibit M, notice of parole violation. Mr. Garcia, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes? It should have been a parole package. Did you have time to review it?
Yes.
Okay. Today we have no witnesses, and it is now your opportunity to respond to the parole charges against you. However, remember that you may remain silent if you choose to do so. Do you wish to testify?
Well, basically, like, speak up for myself.
In regards to the charges.
Yeah.
Okay.
Because the only charge that I would like to testify for is leaving the halfway house. And the reason I left at that time is because COVID was hitting and everybody was getting sick. And I have kids and stuff too. So I had left the halfway house because, one, I didn't want to get sick, and two, I didn't know what was really going on. And then COVID ended up lasting 2 years. So, and by that time I was already basically on the run for 2 years. And, who wants to go to jail then, you know what I mean? So I don't know if that means anything, but that's kind of like the state of the world was kind of crazy at that time, you know what I mean? I know that's no excuse for leaving and violating, the terms of agreement, but that's just where my mind was at that time.
Thank you. Anything further?
No, ma'am.
I'm just going to take a moment before I announce my findings. Regarding charge 1 residence, I make a finding based on your testimony today, as well as State's Exhibits A, H, and L. Charge 2, absconder, I make a finding based on your testimony today, as well as State's Exhibits A, H, and L. Charge 3, drugs, I make a finding based on State's Exhibits A, E, F, and L. On charge 4, halfway house placement, I make a finding based on your testimony today, as well as State's Exhibits A, B, H, and L. And on charge 5, mental health treatment, I make a finding based on State's Exhibits A, C, D, G, H, I, and L. That concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. When I say speak to your background and history, what is your release plan? Do you have employment? Do you have a place to live? Like, what is your plan?
Yeah, well, I do have a place to live. I have an address. I've for the past 5 years, even though I was on the run, I wasn't really doing the same things that I used to do. I have a girlfriend now, and I've been with her for 5 years, and me and her, like, we've been doing better. And it could show I haven't been in trouble in the last 5 years. It's not easy. I wasn't like actively running from the police, but to be 5 years without getting in trouble shows that, I've been doing a lot, making a lot better decisions with my life. You know what I mean? And when I had got this charge, I was a completely different person. I am not that same person anymore. I was really, really big into drugs, and I was depressed. I had went through a divorce, and, my life was spiraling out of control, and I'm at a completely different place right now, spiritually, mentally, and my life is on a different path. I was eventually going to turn myself in because this was holding me back. I've only been able to work under the table, but I want to get like jobs on the books and be a productive member of society. You know, my nephew, he already has a job lined up for me, and you know, and the only thing that's been holding me back was having this warrant over me, you know, but coming to jail is kind of scary, you know what I mean? You don't know if people are going to be like supporting you, and you can't fend for yourself in here, you know what I mean? But I was planning on turning myself in actually January 15th, but they came and got me December 16th. So, but yeah, I'm in a completely different space spiritually and mentally and everything that I was when I got this initial charge that landed me in jail in the halfway house in the first place. Like I feel like a completely different person.
So what's the address you would be residing at?
161 State Street, Meriden.
State Street. Okay,
Yeah,
Meriden.
Connecticut 06450.
And who would you be residing with? Is it your girlfriend?
Yes, Ebony Hunter.
And what's her phone number?
475-343-1168.
So it's 161 State Street in Meriden.
Yes, ma'am.
Okay. And you would be residing, that's your girlfriend, with your girlfriend.
Yeah.
And you said you have a job lined up with your nephew. Where's that at?
Yes, the job is in Bristol. I can't remember the name of it, but he delivers, you know, like the uniforms that people wear when they work in like industrial kitchens, like the smocks and the stuff like that. He delivers those things. He drives around all days, and they have contracts. You can even get your own contracts and contribute to the business.
Okay, so you would be like a driver, essentially, delivering the
Yeah,
uniforms.
driver slash deliverer, yeah. It's good money too, it's weekly pay.
Right. And would you be doing anything else? So working, living with your girlfriend, anything else you plan on doing in the community?
Yeah, I have my children that I kind of missed a lot of time with. So I plan on spending, you know, a lot more time with them and going to church and, you know, and just seeing where that takes me. I'll probably be like an active member of my church and stuff like that. And, you know, and just seeing what else life has to offer. You know, I've wasted a lot of years kind of doing nothing. So I kind of want to like get back into like actually living, you know?
Yeah. Right. Thank you, Mr. Garcia. Just give me a moment before I make my recommendation.
Yes, ma'am.
Hey, Mr. Garcia, being that this is your first violation, since being on parole back in 2020, and this is you were in absconder status for about 4.5 years.
Yes.
But prior to absconding, you were in the community for about 19 days. And in those 19 days, I see that you did receive one infraction, and then you did have a voluntary admission of drug use for the Suboxone.
Yes.
And you did fail to complete mental health treatment. So taking all of that into account, as well as your testimony today, I recommend revoke and re-parole on June 12th, 2025, which is an approximate 6-month sanction with the following conditions: no alcohol, a general contact with marshals in New Britain, halfway house placement in the event that it's needed, and mental health treatment. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board. Your board review is scheduled on March 13th, 2025. So next Thursday, the board is going to take a look at your case. My recommendation is that you are re-paroled on June 12th. So that's my recommendation on June 12th. But the board, it can go lower than that. They can adopt that recommendation, or they can exceed that recommendation, being that you are on parole until May 2026. And you also have 2 years of special parole to follow as well. So so it depends on what the board does on the 13th, but you'll receive the written decision within a week of that time. Within a week.
Do they usually go with what you recommend?
It's at their discretion. So I don't know if it go either way. But yeah, you'll receive their decision, like I said, in writing within a week.
Okay.
Okay. Thank you, Mr. Garcia. You're all set.
Thank you. You have a great day.
You as well. Thank you. Hi, Officer Williams.
Hi,
Still waiting?
I am.
Okay.
The officer just came and told me that they were en route this way, so I'm still waiting for them to arrive.
Okay, that's perfectly fine. If we could get started with Mr. Rodriguez, that would be great. If not,
Okay.
then
Whoever first.
yeah, but
Okay.
preferably Mr. Rodriguez.
Okay, thank you.
Thank you.
You have a seat right here. She's just stepped out door. She'll be right back.
Good morning, Mr. Rodriguez.
Good morning.
Fiona Bowd, are you here?
Huh?
I was asking if your parole officer is still present. Yep.
Yes, I'm here.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Ramiro Rodriguez, inmate number 372609. Today is Tuesday, March 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office at Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Ramiro Rodriguez, 372609.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your parole officer.
Parole Officer DeVilder, Hartford Special Management Unit.
This is a preliminary hearing which has three purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Rodriguez and P.O. DeVilder, please raise your right hand. Do you solemnly swear, or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Both you and the state will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
Wasn't I supposed to have an attorney?
So you have not been assigned an attorney yet. If you wish to continue the hearing so you can be assigned one and see if you're eligible, we can do that. My next available date will be March 18th, but it's solely up to you if you want to, how you would like to proceed.
Just proceed for now. And then let's see if wait, so I can just proceed and see where it goes, and then I ask for an attorney.
So if I find that it's serious enough and make findings, then you would be scheduled for a revocation hearing, and you can absolutely request for an attorney at that time, or you can have an attorney for this hearing as well. But I would again have to continue the hearing so that you can see if you're eligible and speak to an attorney. And again, if you do decide to continue today, then your next date for a preliminary hearing will be March 18th.
Okay, we'll just continue it.
Okay, so you want to continue to wait for an attorney, or you would like to continue without attorney?
No, without an attorney.
Okay. So we just spoke about it, but I'm going to go through your rights. So you have a right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Just for the record, do you intend to seek counsel for this hearing or proceed without counsel?
Proceed without counsel, just for this hearing.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Field DeVilder, starting with charge 1, search.
On 2/14/2025, parole staff conducted a home visit at your Chrysalis apartment. You were in possession of an unmonitored, unreported cell phone with your identifiers such as photo, contacts, home, and work location in the area under your control. You were given numerous instructions to submit to a search, but you failed to comply with the search and inspection. Forensic extraction confirms that this is your cell phone. Charge number 2, no consumption of alcoholic beverages. On 10/24/2024, you rendered a urine that was positive for alcohol. Premier Biotech confirmed that you were positive for alcohol. Per your conditions of parole, you are prohibited from the consumption of alcoholic beverages. On 11/5/2024, you voluntarily admitted to consuming alcohol on 11/2/2024. Per your conditions of parole, you are prohibited from the consumption of alcoholic beverages. Charge number 3, restriction on pornography. Your unmonitored, unreported cell phone contains sexually stimulating and pornographic material. You are prohibited from accessing, viewing, or possessing any sexually stimulating or pornographic material by any means. On the following dates, pornography was accessed on your cell phone: 8/23/2024, 8/25/2024, 8/27/2024, 8/28/2024, 9/1/2024, 9/6/2024, 9/10/2024, 9/11/2024, 9/20/2024, 9/24/2024, 10/13/2024, 10/14/2024, 10/17/2024, 10/18/2024, 11/21/2024, 11/24/2024, 12/3/2024, 12/7/2024, 12/9/2024, 12/13/2024, 12/14/2024, 12/16/2024, January 2nd, 2025, January 8th, 2025, January 9th, 2025, January 10th, 2025, January 19th, 2025, January 22nd, 2025, January 27th, 2025, February 10th, 2025, and February 12th, 2025. On 10/16/2024 and 10/17/2024, you were soliciting and arranging sex with a male on WhatsApp. On 1/20/2025, you received a sexually explicit photo from Aunt via text message, to which you responded, "I will suck the cum out of it." On 21/2025, you requested sexually explicit photos from Aunt. Upon receiving these images, you responded, "I want to fuck you. I will ride you." Charge number 4, no contact with minors. During this period of supervision, you have been in communication with minors. You are not to contact any person under the age of 16 through any means. Beginning October 22nd, 2025 until your date of remand, you are engaged in a Snapchat conversation with your daughter Abigail, also known as Abby. On February 2nd, 2025 and February 10th, 2025, you sent text messages to your daughter Anna under the name Anna, my big baby. On February 10th, 2025, February 2nd, 2025, and February 10th, 2025, you sent and engaged in text messages to your daughter Isabella, also known as Isabella, my big baby. Charge number 5, enhanced internet and device monitoring. You have no reasonable expectation of privacy in the use of any electronic devices. You had IPPC software installed on your only approved cell phone, but have not paid for the software since its installation. You are required to pay for the software program. On February 14th, 2025, you are in possession of an unreported, unmonitored cell phone. Celebrate Forensic Extraction Report confirms that you are in operation of this device. On February 14th, 2025, you are in possession of an unmonitored PlayStation 5 that was logged in and online with your identifying information. You are responsible to report and pay for software programs to monitor the use, which you failed to do so.
Yeah.
Charge number 6, problem sexual behavior treatment. On October 24th, 2024, you rendered a urine that was positive for alcohol. Per your CTPSB treatment agreement, you are restricted from the use of alcoholic beverages. On November 5th, 2024, you voluntarily admitted to consuming alcohol on November 2nd, 2024. Per your CTPSB agreement, you are restricted from the use of alcoholic beverages. You have been in communication with persons under the age of 16. Per your CTPSB agreement, you are restricted from contact with any other children under the age of 16.
The state has filed the following exhibits, starting with Exhibit A, Pio de Valder.
Exhibit A, PCS conditions of parole. B, remand to actual custody order. C, the parole violation notice. D, the parole violation report. E, misconducts, Premier Biotech lab results, and voluntary admit. F, the digital forensic examination report. G, Celebrate extraction information and reports. H, video evidence. I, photographic evidence. J, the video evidence of the consumption of alcohol on 11/2/2024. K, the CTPSB treatment agreement and discharge letter. L, the IPPC report, and M, a revocation hearing summary from 2/21/2024.
Mr. Rodriguez, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
I did not catch that. You said what?
Did you receive the parole package? It should have had a bunch of the documents that were just
Yes.
marked. And did you have time to review them?
Somewhat. I just looked at it, I'm not gonna lie to you.
Okay, so do you feel comfortable moving forward, being that you somewhat looked at them, at the evidence?
It doesn't matter.
Today we have no witnesses. At this time, the state will have an opportunity to make a short statement and testify with respect to probable cause and the severity of the allegations. PO Development?
Yeah, I would just like to mention that the preponderance of evidence involved in the PVR, I think pretty much speaks for itself, and it warrants revocation of Mr. Ramiro's parole.
Thank you. Mr. Rodriguez, it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Could I just take something and just get it over with?
If you can what?
Just take some time and just get it over with?
I mean, so you don't have to respond to the charges. So that's what you're saying, you don't respond to these charges?
No, I need an attorney for that part. I wasn't gonna respond to charges at all. I was gonna get the attorney for that whole proceeding. I didn't do this before. I did it way different before.
Okay, so that was the reason why I asked in the beginning, if you would like to continue this hearing to have an attorney. You don't have to respond to the charges, because if we go the revocation route, you said you're gonna apply for an attorney, which is fine. But in terms of today, I just wanna make sure you want to proceed without an attorney. You don't have to respond to the charges.
I'm good with all this. And this whole, yeah.
Y'all devout nothing further before I make my findings?
No, thank you.
Mr. Rodriguez, I'm about to go on to the findings. Is there anything you want to say before I make my findings? Regarding charge 1 search, I make a finding of probable cause based on state's exhibits A, D, F, and G. On charge 2, no consumption of alcoholic beverages, I make a no finding of probable cause, as the state failed to provide sufficient evidence to prove Mr. Rodriguez's actions meet the elements of this charge. On charge 3, restriction on pornography, I make a no finding of probable cause on parts 2 through 4, as the state failed to provide sufficient evidence to prove Mr. Rodriguez's actions meet the elements of this charge. I make a finding of probable cause on part 1, based on state's exhibits A, D, and G. On charge 4, no contact with minors, I make a finding of probable cause based on state's exhibits A, D, and H. On charge 5, enhanced internet and device monitoring, I make a finding of probable cause based on state's exhibits A, D, F, G, and L. And on charge 6, problem sexual behavior treatment, I make a finding of probable cause based on state's exhibits A, D, E, H, J, and K. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. Your revocation hearing will be scheduled within 60 business days from your return to custody. You will receive a hearing disposition, which will have a tentative hearing date listed, but keep in mind that date is subject to change. And at the revocation hearing, a hearing examiner will determine if you violate the conditions of your parole. So that does conclude your preliminary hearing, and you'll get a dispo with a tentative revocation date, okay?
Okay.
All right, thank you.
Officer Saunders, can I just
Yes.
ask some clarification? So you said no finding on the consumption of alcoholic beverages despite the voluntary admit, the Premier Biotech lab results,
So
the
so
misconduct.
I can clarify that really quickly, but if you
Okay.
want further detail, we can talk later, or you
Okay.
could call my supervisor, only because I have another hearing. But in terms of that, it was more so because of the conditions. Excuse me. Okay.
Yeah, you won't talk later, but she'll read it in the parole preliminary summary, or she can contact me.
Okay.
Yeah.
Okay,
So, all right. So any further clarification? Okay, so you'll get everything in writing. So we're all set.
thank you.
Okay, thank you. Mr. Rodriguez, you're all set. Thank you.
Okay.
You can come on in.
Good morning. I'll be right with you, okay? Thank you. Sorry about that. Thank you for waiting.
That's okay. That's okay.
How do you pronounce your last name?
Eaddy.
Eaddy, okay. Mr.
Yes.
Eaddy, before we get started, I just
Yes.
want to inform you that I did receive an email from the attorney's office. I guess there was an application, and they do have a legal call scheduled with you for March 6th. And so it sounds like you want an attorney, but it's up to you if you want to move forward. But I did want to let you know that their secretary did reach out to me, letting me know that there is a legal call scheduled with you for March 6th. And if you want to have representation, we would have to continue the hearing for today. And my next available date will be March 18th. So it's up to you. I just want to make sure I'm going to go through your rights with you. But before we get started, I just want to let you know that I did speak to the secretary from the attorney's office, and they did they wanted me to let you know that they did have a call scheduled with you.
Nah, I'm okay. I'm okay.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Justin Eaddy, inmate number 419623. Today is Tuesday, March 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Justin Eaddy, 419623.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Eaddy, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without?
I would like to proceed without.
You have the right to receive written notice of charges of violation. You have the right to review that evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, absconder. On June 26, 2024, you left the Isaiah halfway house without authorization. You had no further contact with Isaiah staff or this parole officer. You left your only parole-approved residence without program completion or permission and became unaccountable in the community. Subsequently, your whereabouts in the community are unknown. Charge 2, halfway house placement. On June 26, 2024, you left your only parole-approved residence from the Isaiah halfway house without authorization and didn't return. You failed to contact your parole officer or halfway house staff, and you failed to return to the program. The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, signed parole conditions. Exhibit F, signed halfway house agreement. And Exhibit G, Isaiah halfway house incident report. Mr. Eaddy, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, ma'am.
And did you have time to review it?
Yes, ma'am.
Today we have no witnesses, and it is now your opportunity to respond to the parole charges against you. However, remember that you may remain silent if you choose to do so. Do you wish to testify today?
And when you say testify, you mean like speak on my behalf, or?
Yeah, like in terms of the charges, like for the absconder and the halfway house, do you wish to do you wish to testify regarding the allegations?
Not really testify, taking full accountability, for my, my mistake or whatever the case may be. Basically what happened was I lost a close grandparent, and they basically just triggered me, to relapse. I started drinking again, and I know that was one of my parole conditions, not to pursue any alcohol. It was honestly nothing else. And I think a big thing with me was to relocate. I feel like my biggest mistake was to go back to my old community, being released out on parole. I feel like that was my biggest mistake because, like I said, I'm taking full accountability, but, there's like a lot of triggers, I know with everything that's going on. So I feel like if I would have relocated, I feel like that would have been, a bigger thing. I'm not trying to, find any excuses. I take, I was wrong. I left the halfway house, yeah.
Okay, that's it?
I actually relocated when I was just home. I now stay in Meriden. I have a girlfriend now. I have a baby on the way. My girl, she's 12 weeks pregnant. And, you know, I just felt like me relocating, I just felt like that was the biggest, my downfall, like I said, was going back to my old situation. So I just feel like now I know exactly what I have to do, you know, yeah.
Thank you. I'm just going to take a moment before I announce my findings. Regarding charge 1, absconder, I make a finding based off of your testimony today as well as state's exhibits B, E, and G. On charge 2, halfway house placement, I make a finding based on your testimony as well as state's exhibits B, E, F, and G. That concludes the fact-finding portion of the series. Before I make my recommendation, you will have an opportunity to speak to your background and history. And when I say your background and history, I'm referring to what is your release plan? Do you have a job lined up? And where would you be residing? Sounds like you have a girlfriend. You said you relocated to Meriden. Will you be residing with your girlfriend?
Yes. I have employment out there. I was working with Hamilton Connections. I'm already, you know, that's what I was actually doing when I was in the halfway house. I'm already, you know, plugged. They have an office actually down the street from my girlfriend's house in Meriden. So I do have a plan already. What I really want to do, you know I made a big mistake by leaving the halfway house. That's, you know, so like I said, I definitely do have a plan. I didn't have a plan, you know, when I was released on parole. I just was such in a rush to just go back to my old community, Bridgeport, which was my biggest mistake from, you know, day one. But now I kind of, you know, got an understanding, you know, now I have a child on the way. So, you know, I'm just trying to just do better and just, you know, do positive.
So Hamilton Connections is your employer, will be your employer. Yes. And what is your girlfriend's name?
Her name's Alasia Hamilton.
And how do you spell her first name?
Alayzia. Last name Hamilton, Hamilton.
Okay, and what is the address?
The address is 301 East Main Street, Meriden, Connecticut. I think the zip code is 06450.
And your girlfriend's phone number?
203-694-9849.
Okay, so that's your release plan and your employment. Do you plan on doing anything else while in the community?
Yes, I also plan on getting my barber license. I was in the process of starting the schooling when I was actually home, but, you know, I had to get myself together. I had to handle this, you know, before I could move forward. I plan, you know, to go to barber school because I like to cut hair, you know, on my free time. That's something that I'm good at, you know, and just being a good father, basically. That's it.
Thank you. Mr. Eaddy, I'm going to take a moment before I make my recommendations.
Okay.
Mr. Eaddy, I see that this is your first parole violation since being released on parole. You appeared to be in the community for about 2.5 months before you left the halfway house and went into absconder status. Prior to absconding, it appears that you didn't receive any misconducts or graduated interventions or sanctions. Taking into account that your whereabouts were unknown for about 6.5 months, give or take, and as well as your testimony today, taking everything into consideration, I recommend revoke and re-parole on April 17th, 2025, which is an approximate 3-month sanction with the following conditions: domestic violence, no contact with co-defendants Travis Maynard, no contact with victims NS, AC, and in addition, no contact with TE without the express permission of your parole officer, halfway house placement in the event that it becomes a need. And my findings and recommendation will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on March 13th, 2025. So on March 13th, which is next Thursday, the board is going to take a look at your case, and they're going to either adopt my recommendation, which is April 17th, 2025, or they can go lower than that, or they can exceed that recommendation, being that you are on supervision until September 2025. But you will receive the written decision of the board within that week. Okay, whatever the final decision is.
Okay.
Okay. Any questions?
So if the case was for me to be reparoled, because I have a sponsor, so like, how would that work? Like, would I be placed back inside a halfway house or like?
So that's up to your parole officer. So if the board agrees with that date, then your parole officer will be contacting your girlfriend and doing the
Okay.
checks and make sure it's an appropriate placement. And then if for whatever reason it's not an appropriate placement, then they will discuss with you a halfway house placement.
Okay.
Okay. So
Okay.
any other questions?
No, one more thing, sorry.
That's okay.
I have a breach of peace. I don't know if you see it on the file. I have a breach of peace that I'm going to court for in Bridgeport as of right now. I go back to court March 13th. It's a breach of peace, 2nd degree. When I go back to court, they're gonna, I guess they came to a conclusion. I think they'll be giving me unconditional discharge for the breach of peace. I just wanted to let you know that, that's all I wanted to let you know, basically.
Okay.
Yeah.
All right.
Yeah.
Thank you.
Mhm.
So you're all set. Thank you.
Oh, no problem.
Am I saying, so as it stands, because I wasn't made aware of that information, it's up to your parole officer and PCS to decide if they want to reevaluate you for that charge. But as it stands, you're making me aware of this information. So we'll go from there. But in terms of my recommendation, that stands today.
Okay, thank you.
Okay, thank you.
No problem.
You're all set.
Okay.
Thank you, Officer Williams.
You're welcome. Have a good one.
You too. Bye.
Thanks.
Good morning.
Well, good morning.
You should have, go ahead.
I was just looking to verify the name of the inmate you were looking to see today.
William Leonard.
William Leonard. Okay, perfect. He's on his way. He's en route. We called him down about 10 minutes ago, so he should be en route soon.
Okay.
Okay.
All right. Thank you very much.
You're welcome.
Good morning, Mr. Leonard.
Good morning.
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning William Leonard, inmate number 401193. Today is Tuesday, March 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Garner Correctional Institution. Please state your full name and DOC inmate number for the record.
William Leonard, 401193.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make finding of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Leonard, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury? Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. I did receive email correspondence from the public defender's unit, and they said that you didn't qualify for an attorney to represent you, but you do have the opportunity to hire your own attorney. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel for this hearing?
I'll proceed without counsel.
Okay. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge 1, reporting. On January 13th, 2025, you were instructed by your parole officer to report to Hartford District Parole Office. You did not report as instructed. You failed to make any contact with your parole officer with a reason that would prevent you from reporting as instructed. Charge 2, absconder. On January 13th, 2025, you did not report to parole as instructed by your parole officers. On January 14th, 2025, you did not answer any of your parole officers' attempts to contact you. On January 15th, 2025, Parole made several attempts to engage you at your parole-approved residence. You refused to allow parole access to your home, thereby intentionally evading parole supervision. You have effectively cut off all communication with your parole officer as of January 15th, 2025. Charge 3, obedience to the law. On December 8th, 2024, Wallingford Police Department was dispatched to your residence as it was reported that you were running naked through the second and third floor hallway of your apartment complex, yelling and pulling fire alarms. On approach, Wallingford police officers noted the fire alarms in the building to be going off. You were seen standing in the hallway on the second floor with a small towel covering your genitals. Officers attempted to place you in restraints and you were uncooperative. Based on your actions, specifically pulling the fire alarms in an apartment complex, you were in violation of Connecticut General Statute 53A 182, disorderly conduct. Charge 4, drugs. On January 2nd, 2025, Wallingford Police Department was dispatched as you were reported to have been walking down the street, leaning back very far and foaming at your mouth. You were transported to Midstate Medical Center where you were treated for accidental overdose and illicit drug use. Charge 5, search. On January 15th, 2025, Parole attempted to conduct a home visit and a search of your parole-approved residence. You refused parole entry and subsequent search of your residence. Charge 6, mental health treatment. On November 27th, 2024, parole officers conducted a home visit at your residence. At this home visit, you were showing signs of being in psychiatric distress. You reported to your parole officer that you had not been taking Seroquel medications prescribed to you for your mental health purposes for some time. During a search of your residence, bottles of Seroquel were found in your medicine cabinet, indicating that you had not been taking your medications. Wallingford Police Department were dispatched to your home, and as a result, you were transported to Midstate Medical Center for an emergency psychiatric evaluation. On December 8th, 2024, Wallingford Police Department and EMS were dispatched to your residence. You were asked by paramedics if you had been taking your medications, to which you responded, "No, I have not been taking my medications." The state has filed the following exhibits. Exhibit A, signed conditions of parole. Exhibit B, remand to actual custody order. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, Wallingford Police Department call summary. Exhibit F, Wallingford Police Department case incident report. Exhibit G, Hartford Healthcare Aftercare visit. Exhibit H, Chapter 952 Connecticut Penal Code offense. Exhibit I, contractor message. Exhibit J, Milford Police Department incident reports. Exhibit K, text messages. Exhibit L, Board of Partisan Parole summaries. And Exhibit M, Board of Partisan Parole decision information summary. Mr. Leonard, did you receive the parole violation report and the other documents that were just marked for identification purposes? It should have been a parole package that you received. Did you have time to review it?
No, I didn't. I didn't have my reading glasses. So.
Okay, so would you like to continue the hearing to have an opportunity to review all of the evidence?
No, I don't need to review all the evidence.
So you're comfortable and you would like to move forward today without having an opportunity to read the evidence thoroughly?
Right.
Okay. Today we have no witnesses. Now it is your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Do you wish to testify in regards to the allegations made here against you today?
No, I don't refute the allegations. It wasn't my intention to abscond. I was very confused, but not that matters. Yeah.
Anything further, Mr. Leonard?
No.
I'm just going to take a moment before I announce my findings. Back on the record, regarding charge 1 reporting, I make a finding based on State's Exhibits A, D, and K. On charge 2, absconder, I make a finding based on State's Exhibits A, D, and K. Charge 3, obedience to the law, I make a finding based on State's Exhibits A, D, H, and F. On charge 4, drugs, I make a no finding as the state failed to provide sufficient evidence to prove Mr. Leonard's action meets the elements of the charge. Charge 5, search, I make a no finding as the state failed to provide sufficient evidence to prove Mr. Leonard's actions meet the elements of this charge. On charge 6, mental health treatment, I make a no finding as the state failed to provide sufficient evidence to prove Mr. Leonard's actions meet the elements of this charge. That concludes the fact-finding portion of this hearing. Before I make my recommendation, you have an opportunity to speak to your background and history. Mr. Leonard, when I say speak to your background and history, what is your release plan? Do you have a place to live? Do you have a sponsor? Do you have employment? Like, what would be your release plan?
I own a condo, at least I do now. So, I have savings, so, I have a 401k, so I have sufficient funds to support myself.
And do you plan on working, or you're just gonna live off of your savings?
I can Social Security and savings.
Okay. So do you plan on doing anything in the community upon release?
Whatever I can do. Yeah, I mean.
So you would be a self-sponsor. Where is your condo located?
Wallingford.
What's the address?
The address is 46 South Cherry Street, apartment 245.
It was 46 what? I'm sorry. What was the first part?
46 South Cherry Street.
South Cherry Street?
Yeah.
Okay. Apartment 245 in Wallingford, Connecticut?
Yep. 06492.
Okay. Anything else you plan on? So you have Social Security, your savings, you have your own condo. Anything else? Mental health treatment, anything like that you plan on doing?
Yeah, I will do mental health treatment, yes.
Okay. Anything further before I make my recommendation?
No, other than, I mean, I read a lot. I mean, I'm kind of a single person.
I'm just going to take a moment before I make my recommendation. Mr. Leonard, being that this is your third conviction or your third parole violation since being discharged to special parole, you were in the community this time for almost 1.5 years. It was about 1 year and 5 months you were in the community. Within that time frame, I don't see that you had any reported misconducts. However, there were a lot of incidents of same behaviors from your previous violations that resulted in criminal convictions. So taking all of that into account with your testimony today, I recommend revoke and reparole on October 22nd, 2025, which is an approximate 9-month sanction with the following conditions: no consumption of alcohol, no contact with Melba Street and Milford, Connecticut, no contact with victims CK, MK, PG, GG, JB, and NB, halfway house placement in the event that it becomes needed, and mental health treatment. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on March 13th, 2025. So next Thursday, the board is going to take a look at your case. My recommendation is October 22nd, 2025, but the board can lower that recommendation because they have the final decision. They can keep that recommendation, or they can exceed that recommendation, being that you're on special parole until April 2031. But you're going to receive the board's official written decision within a week from next Thursday to inform you what the final decision is, okay?
Okay.
Okay, thank you, Mr. Leonard. We're all set.
Thank you.